On July 17, 2014, 7-year-old Ryan Paul Batchelder lost his life in a horrific boating accident that was completely preventable. Ryan sustained fatal injuries after being washed out of the playpen seat of a Malibu Response boat and dragged under the boat into the propeller, where he became entangled in the propeller rudder and drive shaft and died from drowning and massive blood loss. As it turns out, Malibu had converted its closed bow model to an open bow by crudely cutting a simple hole in the front of a boat with a saw and dropping a seat into it. Malibu did no testing or engineering to determine if the design would safely accommodate the extra weight Malibu invited at the front of the boat. As its marketing material showed, the playpen seat was designed to hold children. They just made it family-friendly to be more profitable for them. In 2011, 3 years before this tragic preventable accident, the folks at Malibu started to post a 62-cent warning label in the bow of its new Response LX boats about the weight limit, because informal experience with employees and others driving these boats revealed that water would often come over the bow and create a risk of swamping. But Malibu only posted warnings in their new boats and failed to warn owners of its used boats despite its extensive dealer network. In this new insider-exclusive Justice in America Network TV special, Justice in America, Ryan Batchelder's story, our news team is on location in Palm Beach Gardens, Florida, with Don Fountain and Julie Littky-Rubin, partners at Clark Fountain, La Vista, Prather, Littky-Rubin, and Whitman, and Drew Ashby and Max Thelen, partners at Ashby Thelen Lowry, as well as Ryan's parents, Meg Batchelder and Stephan Batchelder, to discuss their major $200 million verdict that sent an unmistakable and resounding message to the boating industry. Malibu Boats bills itself as the world's largest manufacturer of water sport towboats, owning over 1/3 of the worldwide market share. Founded in 1982, it was acquired by the private capital fund Black Canyon Capital and later took the company public in an IPO. It describes its forward-thinking approach to boat design, but the reality was, despite its outsized footprint in the world of towboats, Malibu's design safety features took a back seat to profit and consumer safety. But the failure to hold safety paramount in the redesign of Malibu's Bowrider LX wasn't the first time the boating industry had failed to consider consumer safety, especially with weight distribution, boat design, and subsequent legal consequences. They and every other boat manufacturer, including Malibu's chief competitor, Mastercraft Boat Company, had been put on notice in 2006 when Mastercraft was found liable in a $30.5 million jury award in Butte County, California, for serious traumatic head injuries Nikki Bell suffered in a 2006 boating accident in their defectively designed boat. The sad fact is, in America today, that unlike passenger and commercial vehicles and aircraft, boats are manufactured under few regulations and are not subject to compliance tests to meet a particular dynamic performance standard. The U.S. Coast Guard is the federal agency that promulgates boating regulations, which includes standards related to ignition, fuel, and electrical systems, navigational lights, and safe powering. Contrary to popular narrative, Americans do not live in a world of overregulated products. There are thousands of consumer products manufactured without regard to engineering design principles or safety standards, and without testing or meaningful government oversight. And once in the marketplace, some of those products do great harm, and they did in this tragic case. But as these cases against Mastercraft and Malibu demonstrate, litigation plays an important role in pushing industry to improve. Here is Meg Batchelder, Ryan's mom, to speak about her son and this case.
Ryan was like sunshine. He was so full of joy. It just made everyone feel happy, and he was very funny. He had a great sense of humor. We noticed when he was like 1 year old. He was so sweet and adorable. Everybody loved to be around him. He just lit up a room. After Ryan passed, I wanted to bring comfort to other people that were going through difficult times. So we developed the Ryan Batchelder Foundation, which gives stuffed animals, new stuffed animals to children that are facing challenges or don't have toys. Ryan loves stuffed animals. He had a dream to have 1 million stuffed animals. So that was part of how we came up with this idea. And we work with other organizations such as foster care agencies so that when children are pulled out from their home, they can be comforted with a new stuffed animal. How I eventually came to Clark Fountain was my brother-in-law and uncle told me about a week after the accident, after the service, that something was wrong with the boat. It should never have happened. I went online after they told me, and in an hour, I knew there was something wrong with the design of this boat. So I eventually came to Clark Fountain and told them the story, and Don Fountain had a lot of experience. He was a water skier, so he knew about these boats, and I knew I had the right attorney on my side. What I've learned about the process of justice is it's tough, it's slow, it's very slow. We knew that they knew that they had been negligent. It was very clear from things that you could find online in an hour. And still here we are, 8 years later, still fighting. I want the message of this case to be that people, that these executives need to think about people before profits. And I hope that this message this case sends a message beyond the boating industry. My attorneys feel like my family. Don, Julie, Ben, Drew from Georgia, and Max from Georgia. They have been amazing, amazing support. This was a tough case. Trial was really, really tough, and I can't imagine not having them by my side.
This is the Insider Exclusive, live from Palm Beach Gardens, Florida. It is my great pleasure to introduce Don Fountain and Drew Ashby to the show. Welcome to the show.
Thank you. Thank you.
So that our audience knows a little bit about your firms, because you represent the small guys. Don, tell us a little bit about your firm.
We've been handling these types of cases in Florida since for 35 years. And we represent only people and their families. No corporations, no insurance companies. That's all that we do.
And Drew, that's pretty much what you do in Georgia, isn't it?
It is. We haven't been around as long as they have, though. So I went out on my own about 2 years before this trial. And I've been practicing law about 15 years. And my partners and I have been together just a little bit shorter than that.
Let's talk about the case. Ryan Batchelder, unfortunately, died a tragic death. You took on the case. Tell our audience a little bit about what you discovered in the facts.
What we discovered is this family who went on a family reunion to a beautiful lake in Georgia and rented a boat, had unknowingly rented a boat that had a dangerous hidden defect.
And that was the Malibu boat, correct?
It was a Malibu boat. It was a ski boat. And unfortunately, it had been modified by the company to add more seating to it without any safety changes, without any safety testing. And Ryan, who was wearing a life jacket, lost his life when he was ejected from the boat and caught in the propeller.
Right. And the reason that the boat was modified, I read, please confirm if it's right, is that they wanted to compete with their competitors, correct? Who had ski boats but sat more people in the boat, correct?
Absolutely correct. This was a time where seating in the bow of the boat, that's that front pointy part of the boat, wasn't incredibly common. And Malibu's competitors had bow seating out there before they did. And in order to catch up with those competitors, Malibu took a ski boat that just had fiberglass completely over the front and used a sawzall, like what you find at Home Depot, a reciprocating saw, to cut a big triangle in the front and plop down an isolated seating area where no seating was ever designed.
And they called it the playpen.
And the hot tub.
And the hot tub. And wasn't all the marketing material showing children in there, not adults?
They didn't just design it so that children could be there. They marketed it as a place for you to put your children. And it just so happened to be the most dangerous part of the boat.
Right. Now, what you discovered in the case was that this boat had a tendency, the bow, going underwater, right?
Yes. When the boat was used as it was intended and as it was designed with people in the front, the weight distribution was such that the bow was extremely close to the water, which made it very common for water to come over the front of the boat and swamp the boat. And of course, anybody that was in the bow of the boat, particularly children, were at risk of being ejected into the water and into the path of the propeller.
Right. Now, in the beginning of this show, we also showed you had an excellent PowerPoint of the cutout, the playpen area, and how that boat would, because of the weight distribution, would go under the water. Unfortunately, Ryan was sitting in the front, correct?
Yes, Ryan was in the front left of the boat when it went underwater.
And he was tossed out?
He was tossed out, and he was also wearing a life jacket, so he was in effect floated out of the boat and into the path of the propeller.
Mm-hmm. And unfortunately...
He was wrapped so tightly in the propeller that they could not get him out for about an hour.
Normally, someone might say this is a tragic accident, right? How did it evolve into a legal case?
Well, the family came to us and said, we think there's a problem with the boat. And they had read about some problems of other consumers online having a swamping problem. And so we began looking into it. And after years of prying, we finally discovered that they knew about it and that they had thought about the idea of warning about this problem, but only decided to warn on new boats that were being made, not the ones already in the field.
Right. I saw that some of their employees and some of the people who were familiar with the boat had told them, as you found out in Discovery, that this had a tendency because of the extra weight to go under the water, correct?
Yes. All the employees that had driven the boat testified in depositions that they had themselves experienced the bow going underwater.
So they put on a, as you put it, I believe, a 62-cent warning label on the bow of the boat?
On the new boats being made, they decided to add a warning label. But for the thousands and thousands of boats already in the field, they made a conscious decision not to advise those consumers about the problem.
Right. I have seen this time and time in different industries. You brought up the fact that eventually they had that warning on new boats, but there's a lot of old boats out there, and they had a dealership, didn't they? Extensive.
Extensive dealership.
And the interesting thing I found in other cases is that they have the names of the owners of the boats because they want to sell them something more, right? So in the meantime, they're sending out all of these new ideas for their customers to spend more money, yet at the same time, they don't bother send out a notice about the defective boat that they've already sold them, correct?
Exactly, and that's what we believe the jury was upset about.
Right. Tell us some of what was the end result of the case, by the way?
The case went to a trial in northern Georgia and Rabun County, and the jury ultimately awarded $200 million.
And break that down for me, $200 million.
The compensatory award was $80 million. And the punitive damages, in other words, the damages that the jury felt were warranted because of egregious conduct, were $120 million.
And punitive damages, Drew, are meant to send a message, right? What's that message?
The message is, it stops here, it stops today, and it never happens again. If it's not more expensive to do the wrong thing than the right thing, people will always drift towards the wrong thing. And this is the only chance to hit them where it hurts, which is their pocketbook. If they're going to think and do business in terms of money, they need to be punished in terms of money.
An integral part of this, this case was your partner, Julie, correct?
She was.
And she can't be with us today, but she's on assignment, and we're going to bring her right now, and she's going to be talking about the damage presentation to the jury, correct?
Yes, that was her role at the trial.
So let's do that right now.
When we were considering our damages presentation to the jury in that case, we knew that the Georgia law was based on what the value of the loss of the life is. And that's a pretty tall order when you're talking about a 7-year-old child. And certainly all children are special. But the truth is that Ryan Batchelder was really an extra special child. He was charismatic. He had a compassionate and loving soul. And we wanted to portray that through the parades of people who wanted to testify on his behalf. So, of course, we had his parents, Meg and Steph, who loved him and did a beautiful job of portraying the kind of child that Ryan was. We had some friends and some neighbors, but I think that the absolute best witness that we had was Ryan's first grade teacher. Her name is Krista Jibsuga. And she had started school the week before our trial, and it was very much a hardship. She teaches first grade. It was a huge hardship for her to drive 10 hours from West Palm Beach all the way up to Clayton, Georgia. But she did. She came on a Sunday night. The judge promised she could testify first thing Monday morning so that she could be back at school on Tuesday. And I think it really resonated with the jury that this woman, who had been teaching for over 20 years and had had hundreds of children that she had taught, that this child had made such an impact on her to the point where she would do this, travel all this way to testify on his behalf. And I think that Mrs. Jibsuga made such a poignant and wonderful witness, and she was able to really explain what kind of a child Ryan was. And I think that was one of the keys to our success in our damages case.
Drew, in 2006, there was another really horrific boating accident in California. And it was against one of Malibu's competitors, Mastercraft, correct?
It was literally incredible. This verdict in California, which was $30 million, played into this case for the following reasons. Number one, it was a similar type of incident. It was a swamping incident, which is where the front of the boat goes under the water. People were washed out, and 2 folks in that boat came in contact with the propeller. The boating industry thought very, very little of the case, and it was tried in a rural conservative part of California, and the verdict was, like I said, $30 million. When we asked Malibu why they took certain actions in their own business after that case, they said, because of Bell versus Mastercraft. We couldn't believe that. I mean, we know that cases change things, but this was actual proof from the executives saying they changed it. And that played throughout the entire case. The reason they decide to warn on the boats that they've been producing for 20 years, but only warn going forward and not going backwards, is because of Bell versus Mastercraft. Bell had changed the industry, but not nearly enough. Batchelder versus Malibu will change the industry and will fill any gaps that Bell versus Mastercraft had.
We have with us today your clients, Meg and Steph Batchelder. So let's bring them on right now. It is my great pleasure to introduce Meg and Steph Batchelder. Welcome to the show.
Thank you. Thank you.
First of all, you have my sincere condolences for your son. Steph, tell our audience a little bit about your son.
Ryan was, the number one thing I could say about Ryan was his confidence. The kid would go anywhere, talk to anybody at any time, which is unlike myself, and unlike my older son. That's the thing that I think about in life. Where would he be? What would he do? That's the quality of him that I think about the most.
And how about yourself, Meg?
Well, he definitely was comfortable in his own skin, and we really admired him. But I just think of just how he lit up a room and how he was funny and sweet and loving. And, you know, everybody loved him. Everybody wanted to be around him. Everyone wanted to sit next to him in class. The school did a memorial for him, and they gave all the kids in the class a box with a sticker inside of a smiling sunshine. And they said, you know, when you think of Ryan, open the box because he was everybody's sunshine.
When you, after this happened, it was about a week after this, I think you mentioned to me your, someone mentioned to you that maybe this wasn't just a regular old accident.
Yes.
Maybe there was a reason why this happened, and that reason should be found out So you came to a law firm, and you pursued that reason. That and that was a driving force to find out why this happened. What has been your experience in your situation, Steph, of being in the legal process, and how you have seen things progress, let's say, slowly, reluctantly, and sometimes, oftentimes, the defendants, the companies you're suing, will deny, deny, deny.
Right.
Talk to us about that.
Well, here we are sitting down talking 9 years later. So the case is still pending. The case is still in appeal. And so I feel like it's been the longest drawn out process. But what I want to share is we didn't know what we didn't know. If Meg didn't go and get Don and find Don, and Don do the 5.5 years of work that he did, there's no way that we would have found this out on what Malibu did, how they did it, and how they put profits over safety time and time again, which cost the life of my son in the most brutal, horrific way. And we're still 9 years later having to deal with this. And it infuriates me. And the jury saw it, the judge saw it, and I want everybody in the world to see it, that there's a way of doing business, and customers should come first. And when you cut out safety, people like my son die. And that's why I'm here, sitting here talking to you today.
You've probably had that same experience, right?
Well, I knew before, I mean, much more came out because of what our attorneys did for us. But I knew within an hour of looking online that they knew that there was a problem, because I was on a blog where people were talking about the safety issues with this boat.
Yeah, and the interesting thing is the lawyers brought out, you know, Drew and Dawn, the fact that they were aware of this problem.
They knew about the problem.
Put a label on their new boats, never notified people who had previously bought boats that they were unsafe. They could cause situations like what happened with Ryan.
Yes, and I'm sure they still haven't done that. I would like to know if they have sent those warning labels out now, after the death of my son and after losing the trial for that.
And not only the warning labels, but putting it in the manual,
Right.
the operational manual, right? Like, big disclaimer.
Their operational manual, I looked that up. I did a lot of my own research in the beginning, and I just couldn't believe what I was seeing.
Both of you, you're on national TV. What do you want the world to know about Ryan and about this case?
I just want people to remember Ryan. He was special. And we have a foundation that I mentioned to you before. It's the Ryan Batchelder Foundation, Little Hugs, and we comfort children in need. And I'd like to really focus and expand that going forward. And I want people to have a conscience. I want executives to make the right decisions. I want everyone to see that sees this to think twice about making shortcuts for profit. I don't understand how people can do that. I don't understand the things that came out in this case that were so much worse than I could have imagined. And that's why the case went down the way it did with the jury. They saw it.
We didn't know most of this until trial. Don held back all that information from us, all the research he'd done over the years. I'm glad that he did, but we didn't know it until the trial. And it all came out during the trial, that these people knew there was a safety defect. Their Australian counterpart told them the bow was swamping. Are you guys having these same issues? And their response was, well, they must be fatties. They need to go on the Atkins diet. They didn't ask, well, did anybody get hurt? Was anybody injured? Is there something we could do to our boats to make them safer? They called them fat and said they need to go on the Atkins diet. These are the type of people that are running this corporation who did $1.2 billion last year. Yes, a corporation is a corporation, but a corporation is filled with people that run it. And these people need to do better. And I would like to say one thing to the viewers. If you're in the market to buy a boat, do your research on the management of this company. And I highly recommend you not buying a Malibu boat, because they do not put safety ahead of their customers.
You know, the sad thing is, prior to the accident, which took Ryan's life, Had they changed the boat, had they listened to their insiders, their employees, the Australian quote-unquote fatties, this might not have happened.
Right. It was completely and totally preventable.
And it wouldn't have cost a whole lot of money.
No, pennies. But you know what they do now? They hire the second largest law firm in the world, spend millions of dollars. Well, ask them, call up Malibu and ask them if they sent out the warning labels to these other 2,000 boats that are out there still. I'll guarantee you almost that they have not. They won't spend $2,000 for the safety of the customers knowing that a little boy died, but they'll spend millions of dollars on lawyers.
Well, again, you have my condolences, and I want to thank both of you for sending this message and being here.
I'd like to say one more thing if I could. And I brought it because I think this is a very powerful message from the judge. And this is after 2.5 weeks of trial and evidence being shown. We all know what the jury came out with. Well, this is what one of the things the judge had to say against Malibu's post-trial motions. And I'm going to read it word for word here. Malibu is the world's largest ski boat manufacturer, but its mocking attitude towards safety concerns and repeated deliberate decisions to not warn of a known hazard to life and safety is worse than the darkest stereotypes of a calloused, consciously indifferent company that weighs human lives in terms of dollars on its profit margins. And that human life was my son, 7-year-old son.
Again, you have my sincere condolences, and I want to thank both of you for being here, sending that message. Thank you very much.
Thank you.
Thank you.
We also have with us, and he couldn't be here today, but we have him on Zoom, the expert that you used in your trial that convinced the jury to award $200 million. His name was?
Bryant Buckner.
Let's bring him on right now.
The Batchelder case, from an engineering and a failure analysis perspective, was interesting and unique for several reasons. The first being that the vehicle boat looked very good, looked very well made, lots of polish on it, and it gave the impression that it was safe and stable and very fit for use. But only after running tests and making 3D models, computer models, and we actually made 3D models that we floated the boat, we discovered that the boat actually had a flaw in it that I'll call the fatal flaw. And basically it's that when the boat was originally made, it wanted to float bow up. But then once it was loaded, after it had been redesigned for marketing purposes, it floated bow down. And by floating bow down, it meant that if water came towards the front of the boat, it would swamp. And so we had to determine that. So it was unique in that the engineering for a boat has to be somewhat, or at least the failure analysis of a boat has to be somewhat evaluated from real world testing and real world experience. So we actually discovered that by loading the boat, it floated bow down, and then we looked at what the effect of that would be. And the effect really is that the boat becomes a tub. It holds the water. There was no way to get the water out. So if you ever took a wave over the bow, it was already bow down when you put people in the front. If you ever took a wave over the bow, it got worse. And then the second wave, it got even worse. And then the momentum of the boat caused the boat to plow deeper into the water. So it really kind of defeated itself as a boat with its own design. But that wasn't apparent. Just look at the boat. It's clearly very attractive and obviously had a lot of great design capabilities, but subject to being heavily loaded and start of a bow, water over the bow, it basically sunk itself. So that was interesting. That was interesting, and that was unique about it.
We also have one of your other experts, and you needed experts. Cases come down to experts. Borden Larson. He couldn't be with us today, but we're going to interview him on Zoom.
For me, the Batchelder case was unique. Reading the depositions from the people at the company and just how little they did to respond to the accident. They didn't address any design changes. They didn't put anything into their owner's manual to say, be cautious in these situations. They didn't put any warning labels on the vessel. And this is all based off of just their testimony in the depositions. They may have done things that didn't show up in those depositions, but they didn't mention it. And it was just the lack of action on their behalf, after this horrific accident that I just can't comprehend. When this particular accident happened, the Batchelder accident, I was not working in the industry, in the boating industry, but I can say this: while I was working in the boating industry, we had a particular accident happen, and the engineering department at the company was notified immediately. And within 2 weeks, we had a design change and we implemented it into production, and we provided retrofit kits back for that model year boat. And there was probably a cost increase to the vessel. I would estimate $50 to $70 in that range. It was not inexpensive to make the design change, but it was implemented within 2 weeks to decrease the chance of that happening. So, when I was working at Correctcraft, we took product safety very, very seriously. The president of the company, Walter Maloon, was very serious about safety. If you look at the vessels in that era, in the 1980s, you can see that they were very proactive on warning labels and educating, the users on the potential dangers that do exist. So it's important to, when an accident happens, whether it's your vessel or somebody else's, to do some self-evaluation immediately.
It is my great pleasure to introduce once again Drew Ashby to the show with his partner, Max Thelen. Welcome to the show.
Thank you.
Now, Max, you served not only on the initial team that prosecuted this case, but also you're an appellate lawyer, right? And this case is on appeal. It's 9 years since this happened, right? What are the issues on appeal, and where does it stand?
The issues on appeal are mainly to do with punitive damages and also with some strategic decisions that the defense trial counsel made.
Okay, when you talk about punitive damages, we're talking about that big $120 million.
Well, they're arguing that the award is too high and that it violates due process under the United States Constitution. And our response to that is simply that it's not, and there's plenty of precedent going the other way.
Okay, oftentimes a punitive award is a multiple, maximum of whatever the jury award was, right? Or the compensatory damages, right?
That's right.
So does that fit within that ratio?
It does. Now, it's interesting in this case because there are kind of two ways of looking at the ratio. If you look at the ratio as the entirety of the compensatory damages award, it's very close to 1 to 1 or 2 to 1. The defense really wants to frame this case as looking at the ratio of post-apportionment compensatory damages. Done that way, the ratio is a little bit higher. But it's not a pure ratio test. The court also considers the culpability of the conduct. And here we think it's quite strong, so even a higher ratio would be supported.
What is the other issue of the appeal?
The other issue is some strategic decisions made that the defense trial counsel made. They admitted very early on that essentially the different corporate entities involved with Malibu were all a manufacturer for purposes of this case. Mid-trial, they tried to change that strategy and argued that they were separate, distinct entities and that some were not manufacturers. That involved backtracking on a stipulation that they had agreed to, or attempting to backtrack. and then also trying to argue that we would have to prove successor liability.
In other words, they agreed to a set of rules.
That's right.
In the beginning of the case, and midway, they're now saying, whoa, we're going to be really liable here. We better change the rules.
Exactly right.
So when is this supposed to be heard?
So it's a large case with a large record, so it's taken a lot of time for the trial court to get that together. Mm-hmm. It still hasn't formally docketed at the Court of Appeals. We anticipate that it will in the next month or so, and when that happens, the briefing will be completed in about 90 days, and we anticipate an argument set in the fall.
Now, spending so much time in this case, both in the initial trial level and also on the appellate level, the message that this case sends out is what? Especially in regard to the punitive damages.
I think what's so meaningful about the punitive damages award in this case is that it really was an award to punish intentional willful conduct. They knew about this hazard with this boat and that it could injure and kill people. And on multiple occasions, they deliberately chose to not warn. And I hope that the punitive award sends the message that you cannot and should not do that.
Did anyone ever figure out how much it would have cost to retrofit these boats, or at least put a warning on all of the boats?
My understanding is that a warning that would have prevented this from happening, the sticker would have cost under $1.
62 cents, I think.
That's right.
Wow. It's terrible. Anyway, I want to thank you. Congratulations on the verdict, and congratulations in advance on the appeal. Okay? Thank you for being on the show.
Thank you.
Obviously, these cases bring a lot of attention to both of your firms, right? You have folks contact you and say, can you help us out? You'd like to help everybody, wouldn't you? Right. So how do you determine which cases to handle, and what's your criteria? Drew?
When you take on cases like this, they eat up your entire life. You wake up thinking about it, you go to bed thinking about it. You think about it all throughout the day. The unfortunate reality is you can't take very many of those kinds of cases. They not only consume your time and your energy, but they're extremely costly to invest in over the time period of the case. So we look for cases that meet a couple different criteria. Number one, there has to be a catastrophic injury. Number two, we have to believe that we can make a difference. And number three, we have to believe that we can make a difference in such a way that it is going to justify the time and the expense that we need to invest in the case.
I would say you'd second that, wouldn't you?
Without a doubt. Yes.
Because I think you spent on this case, what, $1.2 million?
Yes.
And my hat goes off to you, and, you know, as many people, when they see firms like your own that are willing to spend their own money because they believe in what they're doing. Because you never know the end result.
No guarantee.
No guarantee. I want to thank both of you for being on the show.
Thank you.
Thank you.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.